Hello everyone, Jai Jagannath. Let's welcome to the another episode of the Lex Dialogues. So today we'll understand one of the another vital entity. What is law? What is the definition of the law? Why we need the law? Why this social engineering is much more essential for the society, for the state to run. So every society runs on an invisible framework that tells us what we can do and what we cannot do and how justice may be delivered. That framework is called law. Law is not just a set of rules written in books, it is the force that maintains order, protects our rights, and ensures justice in society. Without law, freedom would turn into a chaos. मीन्स जदि आमर ल ही रही ताले समस्ते निज निज अनुसार फंक्शन करेंगे तो जदि समस्ते निज निज अनुसार फंक्शन करेंगे देन से कौन ट्रुली माने गोटे गोटे फ्रेमवर्क एस्टाब्लिश हो पार कि गोटे रूल एंड गाइडलाइंस आम डेली लाइफ रे रही पार कि सो से गोटे वन ऑफ द फाइनेस्ट डेफिनेशन जे देइथिले व्हेयर देयर इज लॉ देयर इज लिबर्टी रोसो द्वारा कहला व्हेयर देयर इज लॉ देयर इज liberty. So basically there are certain if you see the certain characteristics of law, means law generally has some features it is made or recognized by the state, it is binding on the people, it is enforceable by courts or authorities, violation leads to sanction or certain punishment. So probably the purpose of a law, if you see the various purpose, it's mostly to maintain the order and stability, protect rights and liberties, deliver justice, and regulate our social behavior. So it is a tool of social engineering. So remember, law is a tool of social engineering, and law is the command of the sovereign backed by the sanction. Means who is the sovereign entity that makes a law. So who is the sovereign? State is the sovereign, constitution is sovereign. So constitution authorizes the parliament to make the law, executive execute the law, and the judiciary adjudicate the law or deliver the means essential justice if law is violated or put certain sanctions. So let's understand what is basically article 13 says about our means what law is mentioned in article 13. So before going to the bare act, let's understand from the concept article 13. Let's understand. So article 13 basically all laws which are means before enactment of the constitution, in 26 January our constitution came to force. So before that some are there pre-constitutional laws, after there are some post-constitutional laws are there. Pre-constitutional laws means before enactment of the constitution certain law exist, because means ता पूर्व तो law किसी थिला सेमती नुहे law नथिला, only constitution आसला पर law आसिला. तो law was existing before the constitution. So those laws which are 1950. So before enactment of the constitution certain law existed, so they comes under pre-constitutional law. Certain laws are there made after the constitution, those are post-constitutional laws. But if you see after the World War II, when it was a very devastating war, means loss of human lives we lost, countries means they are completely devastated. So due to which, so in the era of modernity the paradigm shift has happened and the era of modernity has came. So due to which human came at the center of everything. Center of everything. So during that period, some human right concepts have been originated. So putting them at the center of the equation, every law is framed, means putting humans at the center. Man is essence here. Man is the essence. Laws are not made for the animals or anything. Man has a conscience, and keeping the man at the center, we made the laws. So human rights are there. So other various essential rights are there. So considering this, Article 13 itself shows, Article 13 itself shows, means they took fundamental rights as one of the essence. Fundamental rights, which mentioned in the part 3 of the Constitution. So keeping fundamental rights on the view, they make the laws. So there are certain doctrines as well. So we'll understand what Article 13 Clause 1 says. Article 13 Clause 1 says, those laws which are inconsistent, माने जोटा फंडामेंटल राइट सहित खाप खुआऊ नहीं, those laws will be eradicated, means removed. तो सेठी आमर from there means they have mentioned that all laws inconsistent with the provisions mentioned in the part 3 of the fundamental rights of the constitution remain void. माने जो जिनस गुड़ाक फंडामेंटल राइट्स सहित inconsistent ହେଇଯିବ pre constitutional laws, they remain void. Means suppose there is a law called X. Suppose X is a law. It has some 300 sections, 300 sections or clauses, 300 clauses of the law. So how will eliminate those laws? Means how will eliminate you will completely eliminate pre-constitutional law? It is not possible. You cannot completely void the pre-constitutional law. So which clauses or which laws need to be there? Who will decide? So two doctrines are there. One is Doctrine of Severability, which is also a doctrine called filter out doctrine. Another is Doctrine of Eclipse. So two doctrines they have mentioned, they have used to filter out which laws are not accompanied with fundamental rights. So coming to the picture, let's understand what is Doctrine of Severability. Means suppose this is a जो जाली था मैंने to filter out this is a jerkin. So there is some pre-constitutional law, that is X. So law X has 300 clauses. So out of 300 clauses, suppose 50 clauses are inconsistent with fundamental rights. Fundamental rights means they are they are avoiding the principle right to equality, right to freedom, right to religion, right to other rights like certain cultural rights or many, mostly Article 14, Article 19, Article 21. Mostly if they violating these three rights, most essential rights, those laws are completely void. So what doctrine of severability will do? It will filter out. Means suppose 300 clauses are there, only 50 clauses are inconsistent with the fundamental rights. So only those 50 clauses are removed. Other 250 clauses are passed. This litmus test they have passed. Only the 50 clauses. So you got डक्ट्रिन ऑफ सेवरेबिलिटी माने से छाणीदेव माने जो लज गुड़ाक फंडामेंटल राइट सहित मैच कर कि एसेंस टाक मैच कर इनकनसिस्टेंट थी से गुड़ा को से छाणीदेव बेसिस ऑन द बेसिस ऑफ लाइक दिस ट्रायंगल आर्टिकल 14 आर्टिकल 19 आर्टिकल 21 राइट टू लाइफ एंड डिग्निटी प्राइवेसी ये सब जिन को जदि मैच कर छाणीदेव but only those clauses which are violating. तो ये doctrine of severability वाला है. Come to the doctrine of eclipse. Doctrine of eclipse. Eclipse माने कौन? हमें सुनते solar eclipse, lunar eclipse माने गोटे shadow कर दबा. तो जो laws गुड़ा को certain clauses means like I told 50 clauses are called void because they are not consistent with match करना है essence fundamental right. तो ये जो laws गुड़ा को they are not dead rather what we did these laws are not dead, rather what we did fundamental rights shadow them. Fundamental rights एगुटे shadow कर देछि because fundamental rights also amendable, they can be changes, they are not absolute in nature. Got it? So we'll understand various later point of time. So जते बेले से fundamental rights गुड़ा का amend हे जीवो, these laws again come into action according to that point of situation, maybe with certain changes modification they will come to picture. So eclipse means this doctrine of eclipse what suggests? It suggests that these laws will shadow under fundamental rights. Once the fundamental rights has been removed, those fundamental rights has been removed, so these existing laws they come into picture. So this doctrine of severability or doctrine of eclipse used one of the most essential doctrines for the judicial review, purpose of the judicial review, rule of the law, to establish rule of the law, to define the basic structure doctrine as well in the Kesavananda Bharati case. And doctrine of eclipse also used where there is in a concurrent subject, like there are certain subjects are there, like only central government can, union government can make laws, state government can make laws, certain state subjects are there, some concurrent subjects are there. So whenever union government makes any laws and on same subject state government make laws, the union government law will eclipse the state government law. That is also doctrine of eclipse also applicable there. So now come to the picture, like we understand the two-word doctrine. So article 13 clause 1 suggests any pre-constitutional laws, constitutional law which is inconsistent with fundamental rights remain void. So we use article doctrine of eclipse, doctrine of severability. So what article 13 clause 2 This is suggesting post constitutional laws. Clause 1 suggests pre-constitutional laws. Clause 2 suggests post-constitutional law. It is also telling the same thing, like which are inconsistent with fundamental rights, that will also void. Means tomorrow parliament is making certain law that is violating your privacy, because right to privacy is a fundamental right under article 21, right to freedom, right to speech and expression under article 19. So if any law suppose made by the parliament which void, means which is hampering your fundamental right, then that will remain void, that will called void. By using the doctrine of severability by the Supreme Court, they can declare the law as void. Certain case study you can refer: State of Gujarat versus Ambika Mills. Certain case study also you like some labor welfare fund. Certainly, means you go through that particular case study. It is one of the interesting case study you can understand. So coming to the clause 3. Clause 3 said what is a law. Clause 3. So if you go to the article 13 of the clause 3, that is said what is a law. So which are covered under the law. Means sometimes आमे माने law टा कौन constitution ने खाली जहाँ लिखा है से गुड़ा का law ना हमर किसी गोटे गवर्नमेंट किसी पार्लियामेंट बहुत सारा एक्ट बनाए से गुड़ा का law, some bylaws are there, ordinances are there. तो law कौन, who what comes under law, what comes under law, or what is covered under law, what is covered under law. So mostly in a simplified manner I will say any law that can challenge the legal right of citizens are covered under this. Means any law that can challenge the legal rights, like order, any order, ordinance, bylaw, rule, regulation. Some traffic rules are there, some traffic regulations are there, some notification by the government, some custom are there, some usage is having in the territory. Means जोटा हमर प्रचलित customs गुड़ाक रही, some like Hindu laws are there, family law is there, ordinance हमें बनाऊँ article 123 रे, and so bylaw, rule, regulation, these all are comes under law. Means what are comes under law? Means order, ordinance, bylaw, rule, regulations, any notifications by the government authority, because by the state I defined already what is a state, who can make the laws, customs also, usage, these all are comes under the law. So anything which violating your fundamental rights, you can challenge them on the court of the law, like under article 32 of the writs petition. So we'll understand writ in further session. So let's understand what is clause 4 of the article 13 says. So there is a question for the viewers, like does amendments comes under law? Does amendments means constitutional amendments? Our constitution is there, it is a very flexible as well as a rigid constitution, both flexible and rigid constitution. So does amendments comes under the provision of the law? So there is a fight going on between judiciary. There is an interesting story, like in Shankari Prasad case. So Supreme Court told that Constitutional Amendment Act doesn't come under the preview of the law. But Supreme Court itself changed its verdict in Goloknath case. Like they told, amendments can be challenged. A parliament not have the competent authority to amend the fundamental rights. So, Shankari Prasad case, amendments cannot be challenged under the law. They doesn't comes under the purview of the Article 13. But later of the time, Goloknath case, they told amendments come under the purview of the law. Government in Constitutional Amendment Act, 24th Constitutional Amendment Act, they inserted this clause, Article 30, at 13.4, Article 13.4 clause, they inserted in Constitutional Amendment Act 24th. They told like amendment are not under the preview of the law and they cannot be challenged in court of the authority. So, in the Kesavananda Bharati case, one of the landmark case, Kesavananda Bharati case, Supreme Court agrees that amendment cannot challenge under Article 13. They doesn't comes under Article 13, but amendment need to pass the basic structure doctrine, means doctrine of severability, basic structure doctrine, those need to be passed. So let's hope you understand this scenario. We'll cover this scenario sequence in a different lecture. Like so let's go to the Bare Act. What is the Article 13 itself shows? Like you can see, Article 13 itself shows laws inconsistent with or in derogation of the fundamental rights. All laws in force in the territory of India immediately before the commencement of the Constitution, insofar before the commencement of the Constitution. So our Constitution came into force like 26 January 1950. So, insofar they are inconsistent with the provisions of this part, shall to the extent such inconsistent or void, the laws will be declared void which are inconsistent with the fundamental right, the pre-constitutional laws. This clause told about pre-constitutional laws. So, coming to the clause 2. Clause 2 said, the state shall not make any law which takes away or abridges the right conferred by this part. By this part means part 3, fundamental rights. And any law made in contravention of this clause shall to the extent to the converse to void. ने जो भी law fundamental rights सहित ये part सहित match करूनी सेटा भी void है जीवो. So this tells about post constitutional laws. So जदि आपनकर एग्जाम रे क्वेश्चन पचारिबो लाइक 13 आर्टिकल 13 clause 1 deals with pre constitutional laws, clause 2 deals with post constitutional laws. Then come to the picture, what comes under the preview of the law. Like itself, law includes any ordinance, order, bylaw, rule, regulation, notification, custom or usage having in the territory of India. ऑर्डिनेंस केतବେଳେ बनाଯାଏ ଯେତେବେଳେ ପାର୍ଲିଆମେଣ୍ଟର ଦୁଇଟା ଗୋଟେ ହାଉସ୍ ଆକ୍ସନରେ ନଥାଏ ସେ କୁଲିଂ ପିରିୟଡ଼ରେ ଅର୍ଡ଼ିନାନ୍ସ ମିନ୍ସ ଟୁ ହ୍ୟାଣ୍ଡେଲ୍ ସମ୍ ଏମର୍ଜେନ୍ସି ସିଚୁଏସନ୍ ଟୁ ହ୍ୟାଣ୍ଡେଲ୍ ତ ଅର୍ଡ଼ିନାନ୍ସ ସେତେବେଳେ ଆମେ ବନାଉ ଆର୍ଟିକଲ୍ 123 so order bylaw regulations notification they already comes under the law. So laws in force include law passed or made by the legislature or any competent authority in the territory of India before the commencement of the Constitution and not previously repealed, notwithstanding that any such of law or any part of thereof may not be then in operation either at all or in particular areas. तो सी कह कथा जे जो लॉज गुड़ाक आमर प्रीवियसली रिपील्ड हो जाइछि और जोटा रिपीट हेनी से गुड़ाक जब फंडामेंटल राइट सहित मोस्टली मान एसेंस हो फंडामेंटल राइट सहित जब मैच करूनी ताले सेटा भॉइड डिक्लेयर हो। तो क्लॉज 4 कौन कहूँ नथिंग इन दिस आर्टिकल शैल अप्लाई टू द अमेंडमेंट टू द कॉन्स्टिट्यूशन मेड अंडर आर्टिकल 368। Article 368 itself shows the amendment of the constitution. Will cover the types of amendment, various types of how constitution can be amendment, why it is called a flexible and rigid constitution, both flexible and rigid constitution, and ameda bujile what is law, what is the definition of the law, why we need law to promote social engineering, to conduct the behavior of the people, and the most essential thing is what article 13 says, why fundamental rights are essential, why you need, every citizen need fundamental rights, to understand fundamental right to exercise their law. So gradually furthermore we'll understand further videos like article 14, article 15, article 16, right to equality, those things we'll understand. Thank you so much, hope you enjoy this video. Kindly like, subscribe and share this video. Thank you so much.